Welcome
Mark.
back to the cheerful topic we're on. I'm Larry Froelich. I'm from the University of Pittsburgh. I'm a law professor, and we've got, I am the counterweight to all this good psychological and medical information. You'll notice I'm standing here, and there's someone who doesn't look like me sitting at the end of the table. That's Rebecca Comesher from Altair, and Rebecca will be helping us talk about these issues of financial planning and management of your money from a perhaps a more practical standpoint than I have. All right, now we're going to move to financial and legal obligation and the shifting role of decision making. Let's see if this actually, yeah, oh, there it goes. Legal framework, that worked. First of all, the law assumes that every adult is competent to handle their own affairs. This is really important from a legal standpoint. The law has this presumption, you can overcome the presumption, but you start from the idea that no matter how demented Larry seems to you, legally I'm still competent. I can still involve myself with a business transaction with a guy in Nigeria, for example, no matter how incompetent I am. And now, if I am incompetent and I go and buy a new car and you know that I didn't know what I was doing, you can reverse that transaction. It's possible to go back and say, well, at the time he bought the car, he didn't know what he was doing. We can reverse that. But for our purposes, it means that we start this presumption that everyone's competent. And no other person can legally make personal or legal decisions for someone else. I can delegate that authority to you, the agency that we were talking about, but legally, unless I have formally delegated the right to you to make my decisions, you can't do them. That's how the law sees the world. Now, that's not how the world works, right? We're always making decisions for others all the time, but it's important when we start talking about money, it gets a little more, we want to be a little more hue to the law and a little less informality. The solution for the law for people who have lost the ability to handle their affairs is guardianship. It's known as conservatorship in some states. And in some states, they use the two terms together, but for different reasons. In some states, conservatorship means handling someone's money or financial affairs. If you're in California, that's how it works in California. But the personal affairs, the healthcare decisions, where you live, that's a guardian called a guardian. In my state, Pennsylvania, we have guardians for both, but you can have one person be the guardian who's making decisions about where I live and my health care, and another guardian called the guardian of the estate who handles my financial affairs, or you can put them together and have one person, okay? Now, the reason I'm going to emphasize other states a little bit is that people tend to migrate, right? People tend to go down to Arizona or Florida in the winter, or they go up to northern Michigan up there in the country with the bears and the moose in summer, right? And health problems or financial problems or issues arise, and they've got a document that was written when they were their home state, maybe Illinois, and perhaps Michigan or Arizona or Florida, a slightly different law. And that document that you wrote may or may not be as effective as you want it to be in another state. So you may find yourself writing two documents. One, the state you live most of the time, and if you go out to winter in San Diego, after this last winter, I'm thinking that's a good choice, go out to San Diego, I might want another document that's California specific, right? So I am covered wherever I am needed to be covered. Now, I'm going to take a little pause in the action here. We were talking at the end of the last discussion about healthcare agents, and I just want to go a little bit more into that. We were pressed for time a little bit. And then I'll get back to money and finances. As Marty said, you want to appoint an agent, a power of attorney designating someone to make your healthcare decisions. Because the way the law works is this, as she pointed out. We're autonomous beings. We make our own healthcare decisions. The only time someone else can make a healthcare decision for you is if you have formally designated them in writing as your agent. You're in an emergency situation. That's why they can give you treatment on the side of the road and stabilize you, but they can't do further intervention. And that's about it. We don't have to go into, right? Every time else you have to make the decision. If you're severely impacted by dementia and you have an ancillary health problem that comes up, cancer, and they have to make a decision, what do we do about this cancer? I'll give you a real life problem. My mother, she lived to 97. They came to us and said, your mother's suffering end-stage renal failure. She needs to go on dialysis. My mother at that point was not severely demented, but she was not, you know. Okay, in theory, we couldn't make that decision for my mother. Fortunately, we had her agency power to act on her behalf. What do you do if you don't have an agent? You end up going for a guardian. If there is a serious health problem and the hospital or doctor or nursing home says, we aren't going to do anything without a formal guardian to make these healthcare decisions, okay? So you can get thrown into guardianship because you didn't take a simple time to make a document. It's an agent in many states. Other states call it a surrogate healthcare decision maker. You'll hear the word surrogate, okay? Surrogate healthcare decision maker, you may run into that term. Same thing as an agent. What you want to do is you want to draw up this document. You want to name one person as your agent, not 2 or 3. It's not a committee choice. You want one person. That's because physicians, when they see you have an agent or a surrogate, they want to sit down with that person and start having a discussion about how to treat mom or dad or your sister or your brother, right?
Larry,
right? Go ahead.
comment.
Go ahead, please do.
I am a co-guardian on a case right now here in Illinois. My co-guardian is an attorney in Southern California for his aunt. His aunt is dying, needs to be on hospice, and the co-guardian piece has been a substantial challenge to get treatment done because we have to agree. She should be on hospice. He wants her to continue to be treated because maybe treatment of this 98-year-old is going to impact the future of her life, and she's going to live weeks longer. And it's been 10 days of hours on the phone with the clinical team to finally, yesterday, get her on hospice. And she could have been on hospice back in her facility instead of in an intensive care unit with monitors and all this craziness. So the co-piece take quite seriously as he's talking about it.
But you always want a successor, someone who will step to the plate because your agent may die before you do, or your agent may become incapacitated, okay? Or your agent may have personal life problems that make them very difficult for that point in their life to also making decisions for you. Maybe they have a child who's having healthcare problems. Now do you want them also, doing both? Or here's the more likely one. You name child, my brother Tom, he's the agent. Tom goes off to Italy for a month. He's having a great time backpacking, or make it more Bhutan. He's off, he's off the grid. My mom suddenly needs healthcare decisions made. Tom is unreachable. Well, if you have a successor, moi, you can have me step up to the plate for that month and make the decision. So you want to have at least one successor, and maybe 2 if better, okay? Finally, on the Post, which is a really important document. The reason we lawyers have been, yes, go ahead, I'm sorry. Excuse me, we'll give you the mic and share this with the whole class. This is not a class, I'm sorry. All right. Well, go ahead, I'll repeat. When you're talking about state-specific, right?
Would you recommend in each state having the same person?
Yes, you want to have, what you're trying to do is make sure you're meeting the procedural formalities that state may require, whether it's notification, whether it's witnessing. Pennsylvania now, for example, on powers of attorney for property, you have to put a warning on telling the person that you can't steal the money, essentially. But you want the same person, unless you could have something like this. You might have one child in California and one in Illinois. Mom goes to California every winter for 3 months, right? You might want to write the document that when mom's in California, the agent is the California child, assuming, in fact, everyone thinks that makes sense in terms of the personality and the capability. But usually you would have a single person, and what you would do is have the California child be the successor. Mom goes to California, she has an incident, medical incident, she needs some decisions being made. You're tied up, you got your life in Illinois. So you call up the physician, or you call up and you say, I am now temporarily withdrawing as the agent. My brother is the successor. He will handle the decision-making now in California until such time as I can feel like I can get back in the groove and help out. So you might do that. All right. PULST, the reason the lawyers are not allowed in PULST, thank God, is because the PULST, remember that physician's authorized treatment document? It's a wonderful thing. The idea is you and the physician sit down and you plan your end-of-life care. It requires that you have something going on with you, that you're going to have end of life coming up. This is not a document that I write today. I write this when I'm in end-stage cancer. And I sit down with my physician and say, what do we do now? It doesn't sound very good. We tried, and I'm still getting worse. So I sit down with the physician, and we diagram a care plan, okay? That gets put on this fuchsia paper, and gets into my it's on fuchsia paper, so people will notice it on your medical chart. So when it's on the end of your bed, someone, oh, what's this? Right? And it's supposed to follow you if you go to a nursing home, and they see a big, bright piece of paper. And typically, but not necessarily, a PULST will ask that care be terminated under specified conditions, okay? I don't want this or that. Now, if you have reason to want care, and there are people who, often it's a religious belief, right, but not necessarily, that can say that. I want a lot of care, even if it doesn't look very promising, please do it, okay? So that PULST tends to be end of life, and in some states, they actually run out. That is, if you have to redo them after a year. If you don't die in that first year, you got to redo the thing. So, but if you have an older family member who has a serious health problem, and it looks like this might be end of life, you should talk about getting them a PULST. Now, if they have dementia, they can still sign a PULST. They can still sign a power of attorney for health care, because the level of capacity needed to sign a valid agency isn't very high. It can be fairly low. As, you don't have to get a 700 on your SAT to be able to appoint an agent, right? They still use that number. Showing my age here. If I had a parent, or if it was me, and I knew I was in early stage dementia, I would make darn sure to get a power of attorney for healthcare signed as soon as possible, if I didn't have one, and review the old one to make sure it still makes sense. Because down the line, when the person loses capacity, no one's going to jump up and say, is that document legal? Did Froelich really know what he was doing that day? No, that's not going to happen.
Larry?
Yeah.
Here in Illinois, when I work with elder law attorneys, they are very cautious about the level of cognition and decision-making capacity before they're allowing, just because of the family dissension.
Yeah, that's the coda. The only time you got to, and that's why the lawyers, if you fear there's family dissension, if I'm named the decision maker, but I know my sister thinks she should have been named, and I know, and it typically happens like this, you'd have more war stories. Mom and I have talked. I think Mom doesn't want a lot of aggressive end-of-life treatment, so I'm willing to not do that. Sister is not on that page. She wants Mom to be alive as long as possible. So I go to the physician, and I got the power, I got the agency, let's not do this for Mom. Sister comes bursting in and says, that document has no validity, Mom didn't know what she was doing, he was just telling her what to do, don't pay any attention to that. Well, you don't want that to happen. So in that case, you got to be a little more careful. Okay, that's PULST. And yes, but except for our questions, yeah. And you're sure we got other people. I'm not the expert in this. So, yes, sir. Hold it. Coming from all directions.
All sides.
One per customer.
I remain confused over the differences between a PULST, a DNR, and a healthcare power of attorney.
Okay, I'll take the power of attorney and leave the others to them. The power of attorney for healthcare simply says, if I am unable to understand information about my medical condition and to act on that information, that is, like, I take in the information, make a considered decision, and then make a decision. If I lose mental capacity and cannot do that, I forego that. I appoint Larry to have my agency, meaning he stands in my moccasins, can I say that? Right? He can make all the decisions I would make. Okay, he's my agent. So he's me. Instead of talking to me, I'm lying confused on the couch, I don't know what's going on. You turn to Larry, and you have the dialogue about my health care, and he makes the decisions, okay? A DNR is a do not resuscitate order, which essentially means You want to explain that? Because I think I know, but I think I would prefer you do it.
A do not resuscitate means I do not, if my heart and lungs both stop working, I do not want anyone breathing for me or pumping on my chest.
Okay, yeah.
No
electroshock.
I-
You know, put
Don't
the
try to
paddles on.
revive me if I look like I'm dead.
No, but yeah, right.
Right.
But the DNR is the do not resuscitate is something you and I could sign right today. And it says whenever down the line, although some states may have time limits on these, you know, you have to renew them, but okay. And typically we don't do them. When you're in good health, you don't, she's unusual. Most of these DNRs are signed by people who've had a health incident, right? And the question is, if their heart stops beating, do you want to do the famous TV scene where they put the paddles on you, clear, you know, we have all seen it, right, on television. Or they start beating on your chest. What they don't show on TV is when they're beating on your chest, they're breaking your ribs, because you're older usually, and the force you needed often causes rib break.
Do not resuscitate, we would still shock you. We just would not do compression.
Okay, you still shock them, okay, because you can do that. Okay, that's why I'm glad you. And you don't get put on a ventilator, they're pumping oxygen in. And here's why this is all important. I think I've got this right. The classic definition of death used to be lack of breathing and cessation of heart, lack of respiration and lack of circulation, right? Mm-hmm. That was death. We learned how to cheat death, as it were. We can bring people back to life from that condition by artificially stimulating the heart, by pressing on it, and putting them on a ventilator and causing their lungs to work by pumping air into them. All right? Now, sometimes you can come off the ventilator after a while. They call you weaning from the ventilator, and your lungs will work on their own. But you've been clinically dead, and they brought you back to life. Why would you not want that?
Because if your heart and lungs both stop, well, first the history.
This we got out of it, just
Okay,
quick.
cardiopulmonary resuscitation was initially established in the late 50s, early 60s for cardiac or irregular heartbeats. So if everything else is normal and your heart has a spasm and is going to be able to get over that spasm, then we started cardiopulmonary resuscitation. Today, cardiopulmonary resuscitation is used just really generally. And so if I am in multi-organ failure, means my heart's not working, lungs not working, kidneys not working, brain's not working, you still may be able to salvage me doing cardiopulmonary resuscitation. And the best, from a statistical standpoint, if you review the literature, if you have a cardiopulmonary event, your heart and lungs both stop working, in an intensive care unit, the best hospitals, the survival of CPR is 28%, which means we will bring you back to life, breathing and your heart working, but I cannot guarantee that there will not be other organ damage because you haven't had adequate blood supply and oxygenation during this time when your heart and lungs were not working.
And by the way, that's in the ICU. Out in the real world, on the sidewalk, it's about 5 to 10%. It's not what you see in the movies.
If you
Most
are,
of the time it doesn't work.
in the movies, it's 75% success, and it's usually from trauma. If you are 80 years or older and have multiple conditions, which we do as we get 80 years old, other medical conditions, you have a 1 to 2% chance of survival of the treatment. Not bringing you back to where you were, but survival, and survival means your heart's working and your lungs are working. So the reason that we do not resuscitates is, as a clinician, if you come to the emergency room and you do not have these documents, I must do everything. If you do not have a do not resuscitate signed by a physician and witnessed, I must do everything.
Yeah.
And this is,
I'm sorry.
Okay,
We'll
this is
we have an
about-
extra hour at the end of the day, so if we haven't got it yet, that's a great topic to spend more time on. But I'm going to insist. I'm going to grab
Okay,
back the
that's fine.
podium
Yeah, please do.
and get going here. Okay. Guardianship. Clear on mind. Let's
Yeah.
forget that
Sorry.
forget people jumping on your chest and all that. We're just talking about dollars. They're jumping on your wallet, not your chest, okay? So here, let's talk about money. That can be a pretty serious topic, too. People who can't or make or communicate reasonable decisions are in need of a guardian. Now, each state has a guardianship law that differs from state to state. But essentially, that's the core thing. If you can't make reasonable decisions, you can have a guardian appointed for you, which means you can make dumb decisions. You can make stupid decisions. But as long as you are capable of making a reasonable decision, you're on your own, okay? Guardianship is not to keep people from doing stupid things. It's to keep people who can't make a reasonable decision from trying to handle their own affairs. You should never need a guardian, I'm going to tell you. Okay. And they won't appoint a guardian unless there's no acceptable alternative. And this is important. I could be very demented and meet the standard of unable to make reasonable decisions. But if I've put other things in place, powers of attorney and such, the court should not appoint a guardian and override my private personal decisions I made prior to the problem. You'll see this happen sometimes. Larry's pretty demented. He's got everything in place. Things are going along smoothly, but one of the children decides they don't like what's happening. So they come into court and they want to get a guardianship. And it's clear I'm demented and I can't make decisions, but I don't need a guardian. I've got these other things in place. And so probably the court won't appoint a guardian. So you can forestall a guardianship by proper planning. The reason you don't want a guardianship, it's costly. You've got to pay a lawyer to bring a petition in court saying I'm incapacitated. You've got to get a doctor to testify, not usually in court, but by deposition or interrogatory, doctor to testify why I'm incapacitated. That is, it's not just that
Remember
I'm
that Lillian Bettencourt whole thing and,
Right,
and Donald
right.
Sterling?
Or you get someone
and all-
like Bob to come in and say, because what the court wants to know is he just acting loopy, or is there a medical reason he's acting loopy? Because I can be loopy on my own. It's, he's always been that way. Okay. It's potentially public. It's in court. These things can get out in the public. Finally, it's a source of family disharmony. People disagree. One of the biggest things you see in guardianship cases is everyone agrees mom or dad's incapacitated, but the children are fighting about who should be named the guardian. And you get deep, deep fights, whether it's really about the prom dress 50 years ago, who knows? But they're still out there in court fighting out, burning up money, family money, fighting about who should be the guardian. And it comes too late. Because by the time you can get someone declared incapacitated, they can do a lot of bad things with their money and finances, all right? You can make a lot of bad investment decisions in mild cognitive impairment stage.
Especially, yeah.
Especially at that point, because you don't know you're slipped. The family either doesn't observe or is in denial, and you're hiding your financial affairs perhaps from them. This is particularly a problem, of course, where there's a single survivor of a couple or one member of the couple has control and the other doesn't know what's going on. So they're doing things which are not very good, but yet they're not legally, even if you were to take them to court, they could pass a capacity test. They've got diminished capacity, but they're not loss of capacity. And you want a system in place that will help families to intervene long before the person is legally incapacitated, long before they start making decisions, which they would, if they were, but for the lack of incapacity, they would really regret these decisions. The alternatives are simple. Your goal is to plan for a gradual or swift change of a decision-making authority. I could have a stroke like my father did, and he lost his ability to speak, and his reasoning powers declined. He went from pretty darn good shape to boop, just, down here. Well, we needed to get right in there and start dealing with his financial affairs at that point. Or it may be gradual. My mother probably lived to 97, and the last few years of her life, She also had macular degeneration, so she couldn't read for a long time. She couldn't pull in information, and she starts having normal aging, short-term memory problems, then maybe some dementia. Who knows? It's, you know, it's hard to know. But we needed to, with my mother, it wasn't a question of coming in one day and say, hold everything, we got to do something. It was rather, little by little, we've got to enter in with my mother and help her and eventually take over the decision making. So it was a more gradual transfer. If you want to say. Yeah, go ahead now.
That having
Rebecca.
the plan ahead of time and known can also help your other advisors. So for our clients, we often see their power of attorney ahead of time, and if we're noticing certain things or forgetfulness, things like that, people making decisions that seem outside of their norm, we can look at that and know who to go to, maybe who they appointed as someone they trust, either their spouse or a child, and we can perhaps approach that person and see if they're noticing the same things, maybe start the conversation about enacting that plan.
Yeah, where you may be reluctant to go to the client directly and say, we think you got a problem. And that's human nature, right? But they might, if they know I'm the agent, they could call me up and say, did you know that your father did X, Y, and Z? Seemed a little unusual for your father. That's not what he normally does. I noticed my father built up an incredible amount of money in an interest-free checking account. My father was the kind of guy we'd drive halfway across town to save 15 cents on laundry, right? So I knew something was really wrong when he wasn't reinvesting this money. But that's the kind of thing where a financial advisor can call up if they know who is to be called up. And then you can start the discussion. And in my case, I sat down with my dad. We, quote, together, allegedly. I really just told him what to do. But we were able to keep his dignity and help start solving this financial problem. There are two kinds of power of attorneys. There's something called a springing power of attorney. You don't want that, so I didn't put it on the slide. And the standby. I call that remember the Ben E. King song, Stand By Me? Anyone? That's the Ben E. King power of attorney. Okay, if you don't know that, let that go. Springing power of attorney works this way. It says, if I become incapacitated, Bob becomes my agent. But not until then. And how do you know I'm incapacitated? Typically, the document would say, when two physicians certify that I'm incapacitated. You don't want that. It's really hard to get that power of attorney activated because you've got to take me not to one assessment, but to two assessments.
Yeah, we will have to talk about that, the capacity of physicians to do
Yeah,
a capacity
I don't even want to
evaluation.
go there. I'll let the, and we're not even talking dermatologists here. We're talking about internal, medicine people typically.
Right.
So you don't, I'm not going to spend a lot of time on this. These used to be popular. They're a bad idea. They're just a gate. They're good for lawyers because they often cause litigation as people fight about them, but they're not good for you. Standby works this way. I name Bob my power of attorney. He's my agent for my property right now. He can start today, as soon as I sign it, he can start taking steps with my property. Okay? Whoa, what about that? I don't want him doing, no, I don't want Bob selling off my stocks today, reinvesting in Nigerian oil futures. No, I don't want that. So how do I stop that? Well, first of all, I got to trust Bob to name him my agent, right? But trust is one thing. Giving him the power is another. What you do is the power of attorney is signed. You make multiple original documents. And your attorney, financial advisor, I don't know, do you hold powers of attorney for people? You probably don't. You probably don't want to go get that liability issues. Attorneys hold them, accountants hold them, something like that. Or your client holds them. My folks had one. They just kept it in a file in their house. I knew where it was, but I suppose I could sneak in there and pull out well, actually, it probably was locked, knowing my father. So, as long as I don't have physically the power of attorney, like to show somebody, I can't go to Vanguard and say, here's my power of attorney. Bob can't go to Vanguard and say, I'm Larry's power of attorney. I'm agent. They say, fine, show us the power of attorney. He says, well, I forgot it. It's back home. Not going to happen. Vanguard won't do anything until they see the physical power of attorney, and that's not released typically by the attorney often. Someone calls up, Bob calls up and says, Larry's having a lot of problems. I think I need to get that power of attorney in hand so I can start doing something. The lawyer investigates a little bit. Bob's telling the truth. Time to get the power of attorney out there, and Bob does something, okay? So you have a standby power of attorney, just very similar to the healthcare power of attorney. You only want one person as agent for all the reasons. You want a successor agent, 2 or 3, because typically people name their spouses as their agent. okay, he or she, and then, but they die or get incapacitated, so then you need somebody else, next generation down. The problems with powers of attorney, powers of attorney can have problems. You got to get third parties to accept them. Bob walks into the bank with the power of attorney form and shows it to a community college dropout who's standing behind you. He says, I want to get money out of Larry's account so I can pay his bills. And the kid goes, I don't think so. No one ever got fired for not honoring a power of attorney. Lots of people got fired for honoring a false document, something Bob wrote up on the way to the bank. So you're going to have third parties that get very, very careful about honoring a power of attorney. How do you get around that? Well, first of all, you contact the entity. They may have their own form of a power of attorney. I happen to know the Vanguard has their own form, because my sister wanted me to be her financial power of attorney. We tried to do this, and she has Vanguard accounts, and so we had to go to Vanguard. They sent her a power of attorney form. That's the form they want, okay? Legally, they should honor the one she signs. Forget law, right? You don't want the law, you want action. So talk to whoever holds your accounts, make sure they don't have a form they want you to use. If they don't have a form, show them the form you've got and say, is this going to work? If, you know, is this going to get me access to the account, et cetera, et cetera, et cetera. So you do that. You plan ahead. You make sure all your ducks are in a row in terms of people will honor that power.
Larry, maybe this is a point.
Yes,
Can
yeah,
you talk
please
for
do.
Altair in terms of the kinds
Yeah,
of forms or
so-
you've looked at? And
Yeah, so most of the custodians, like Vanguard you mentioned, that we work with do require their own forms. So we would have the person who's going to be the power of attorney complete those to get control of the actual assets at the custodian. And then with Altair, we actually, any client can delegate their investment authority to any other person. So it's not necessarily a legal form, it's just a direction from the client saying, I'm delegating to this person to act as my agent to give direction to Altair over my accounts.
Right. That's
So
another-
there's sort of a two-level.
Sure, because you sign a contract as their investment advisor, and within that contract, we can agree that if I can delegate Bob
Right.
without a formal power of attorney, I can call you up and say,
And
at this
often
point,
clients do it for all different reasons, not
Right.
just incapacitation. Like the one spouse just doesn't want to be involved in the investment decision, so he might delegate it to his wife or vice versa. Or a child might take over for the parents with us, even though the parents are still have enough capacity to deal with the actual custodian when it comes to doing those decisions. He might tell us what they want to have happen, and then they can still sign the forms.
well, that's a great,
Well,
see, this is a great, I'll give you a second, but that is a great advantage of Altair. I'm not trying to plug it, but that really is. The ability to have, they're already looking down the line. They know you may want someone to act on your behalf, and this allows that to be in place very
And
comfortably.
I think all of the clients who are in the room know that we have very close relationships with our clients and often with other generations in their family. So often things do happen gradually with dementia and other problems. And so these powers can be sort of put in place over time. Maybe the parents don't want them to actually be able to move money, but they want to be at the meeting with Altair and learn how to make the investment decisions, and then it can sort of happen gradually.
there are, because of my work in the wealth management industry of family offices and multifamily offices and stuff, one of the things that I've often been involved with is the idea of there's a general beginning gradual movement in many wealth management firms to be looking at proactive documents that address this. And Anna made reference to Ballantine Partners, who I know, and that they have a form. There's some other wealth management firms I know of around the country where there's beginning to be a set of things, articles in Journal of Financial Planning about this. And it's really a great movement because of a couple things. One is about if the advisor is seeing changes and is the one to first speak up, or between a couple, and to be able to notify children. And it really speaks to being able to have relationships with other family members and other generations. But also the idea of being able to interact with the healthcare system. We can get into it a little bit later, but one of the things is the whole idea around confidentiality and privacy and disclosure. And one of the main things that often people run into is if an evaluation is done on a client, the advisor often cannot get access to or know about something that actually somebody's been determined not to be competent. They've had a neuropsych eval. And so some of the newest forms actually address the issue of creating the opportunity of release of any evaluations, discussions with physicians and things. And this is now becoming a little bit more known around in the early part of the client relationship. You know, someday, as a normal part of our procedure, what we do is we look ahead to an eventuality in which you may have difficulty, and we would like to discuss with you and have procedures in place that in the event that you start having something going on with you that's going to impact your money, your health care, other sorts of things, that we want to be proactive and collaborative and act as a team. So they're beginning just to alert you that there is a movement to embed documentation like this in wealth management to be proactive about it.
Absolutely, and that's, it's, thank goodness is all I can say. It's the right way to go. Joint accounts. How many people got joint accounts other than your spouse? Okay, rethink that. Joint accounts can be, cause a lot of litigation because it's not clear what the intent is. Does the other parties take all the money when the one party dies? It's called survivorship rights. One of the reasons people set up joint accounts is often for an older person, just so they can write checks on the money and get things paid. It seems like a simple way to go. There are other ways you can do that. You can have a signature account where you're not a joint holder, but your signature is enough to, on a check to get money paid. That makes it clear that the money still belongs to the older person. You're just writing checks. That's very helpful. Unfortunately, and no one here would do this, but there's an awful lot of fraud with joint accounts. So lots of people, you would just be amazed how many people are over-tempted when they have a joint account to take the money out for their own purposes, often when they have problems in their own family or they have addiction problems or something like that. So you typically don't want to get into joint accounts if you can avoid it, other than for maybe small amounts. One other thing, the power of attorney. Okay. Finally, revocable living trusts. Now, one of the things that a lot of people do these days is to have their money, their assets put into a trust as they age. Not the house necessarily, but the liquid assets, your investment accounts. The trust is revocable. You are the creator of the trust, you are the beneficiary of the trust, and you are the trustee of the trust. For income and estate tax purposes, the trust doesn't exist. You're still taxed just as if you own the money. This is not a tax device. Why do you do that? You create the trust, and the trust says, in case you lose mental capacity, and if you can't handle your financial affairs anymore, you can have the money in a trust, and when let's imagine a husband and wife, and the husband loses mental capacity, the wife's a co-trustee, she can now manage their affairs without the husband, because the money's in the trust. She doesn't need a power of attorney, she's the trustee. Father dies, mother stays on as trustee, she becomes incapacitated or doesn't want to be trustee anymore. Maybe couple of her kids, adult children, now become the trustee. So mom's trust exists, mom's the only person the kids can spend the money on. Okay? They can't spend it on themselves. How much money they have to spend on mom? Different lawyers have different solutions. Common one is all the income has to be given to mom. All the income and such amount of capital as you might need for health, in case she has a special, has to spend a lot on her health care. There are a variety of ways you can do this. So you have a trust now. The children are talking to your, investing in money, talking to Altair, right? About things to do. The money, all the money the income produced by the trust, and you can define that in different ways. Of course, you can invest the money in such a way that you don't produce much income, right?
Right, so I actually would say we would discourage the all income from any trust and do some sort of unit trust position.
Right, yeah, we go
provision
unit
so
trust.
that
I'll
it
get to
doesn't-
unit trust in a second, thank
So
you.
it doesn't
And
sway
the reason you
investment.
discourage all income is because
Yes.
income is such a tough thing to define. You can
So a
imagine.
unit trust is distributing a fixed percentage versus all of the income
You
so
might
that
say
you're not.
4% of whatever the thing's worth on January 1, the next year give me something equal to 4% of that. So if you had
So
$10
you're
million
not swaying
in
the
the trust.
investments one way or the other to produce income or not to
Right,
produce
so
income.
It means you know how much income you're going to pay, you adjust the investments to meet that goal, and you don't get in these shenanigans of trying not to produce income but to get a lot of capital to keep growth in ways that will pass to the next generation and not give to mom. Right? Okay, it's a very good idea. So what you have is this trust throwing off cash, maybe under a unit trust. So maybe it's supposed to throw out $20,000 a month. Just take a number, arbitrary number, right? Every month, $20,000 goes from the trust into a checking account. The power of attorney, someone has the power of attorney to write checks on that checking account. Maybe not the trustee, maybe another child. And that, out of that checking account, you pay all of mom's living expenses, right? Whatever she needs to survive. You can get access, and if it builds up more, then you put it in, buy some more investment money or whatever. But you can do whatever you want. The point is, you have a power of attorney person who's doing the day-to-day bill paying. Maybe that's the child who lives in the same town. But maybe the trustees are the two children who live far away but are really sharp cookies when it comes to investments. So they become the trustees. Now mom dies, the trust is ended. Now, she might provide the trust to continue, but it's over. The trust is over, and the money is distributed as mom dictates, okay? So a living trust, inter vivos, using Latin, inter vivos living trust, is a way to manage have your property managed inside a trust document rather than through powers of attorney. You will find banks and investment houses and other people like that are much happier dealing with trustees than with agents under a power of attorney. And the reason is we have 300 years of law that tells us how a trustee is supposed to do, what they're supposed to do, and when they're supposed to do it. Got a lot of law. We really know that. Powers of attorney, not so much so. Not so much so. We're not exactly sure what's right for an agent under a power of attorney to do. So everyone gets a little nervous. And so what you really want in life, and you go to a lawyer and you're doing your estate planning, is you're going to want a will, right? You know, I did. Who gets the money? You're going to want healthcare power of attorney. Now, why do you talk to the lawyer about that when you're doing these other documents? Well, because they'll throw it in for free. They'll give you a nice healthcare power of attorney. Now, I want to say one more thing about healthcare power of attorney. You sign one, as Marty points out, you got to revisit it every 5 years or so. No one wants to pick up a document. No doctor wants to see a document that says, geez, 1993? Is this still, right? You want something that looks fresh. You also want to revisit it if you have a relative who's aging and has a significant illness. You want to rewrite the power of attorney for health care, and you want to revisit what kind of treatment would you want in light of this particular illness, okay? Now, you can either put it in writing, which is not a bad idea, but you certainly want to talk to the agent. So you want to get out of these generalities down to the hard realities of this is my illness, this is what the physician says the treatment options are, this is what I want my agent to do in light of those options. It's a decision tree. You're always going X, Y, or Z, right? And so you want to do that. So you want a will, you want a durable power, you want a power of attorney for health care, you want a power of attorney just so someone can access your checking account. Someone's got to pay your real estate taxes. Someone's got to object to the re-evaluation of your house for property taxes, file an objection, right? It's just these little things like that. So you got to have a general power of attorney. You want a lawyer to write it up, and you want it as broad as possible because you don't want to miss something. But you also want a power of attorney that's adapted to your financial realities. If you own a company, a family enterprise, you may not want a general off-the-wall power of attorney. You may want to be detailed about the agent's responsibilities inside this family corporate structure, right? So you want to be thinking about what kinds of powers do I need to give to somebody in order for them to carry out our family's larger family values. Okay, so you can print one off the internet, but I would sit down with an attorney and talk about this is the family situation. What powers do we want to give, and what powers do we not want to give? Okay. Among other things, if you've got insurance policies, for example, business buyout insurance policies, right? You're financing a buyout. You want to make darn sure no one can change the beneficiary of those policies, right? because those policies, that's supposed to produce $1 million, and that $1 million isn't for go around the world on a trip. It's supposed to be the buyout to finance the buyout. So you don't want, things like that you got to think very carefully about when you give a power of attorney. It's a powerful document. And finally, you want, in many cases, you want a trust, a living trust. You can dump your money in, so if you lose the ability to handle it, you have someone who is a trustee. Now, that means it gets a little complicated, right? What do people have to do when they have these living trusts?
So we definitely have situations where this has happened, and he's totally right. The brokerages and banks prefer to have assets in a trust and will much more readily accept direction from a co-trustee than a power of attorney. I think I wanted to speak to your point earlier a little bit. Altair hasn't gone down the route of having a formal conversation with each client about what happens if we notice signs of incapacity, because I think there's just a huge gray area there. We see clients maybe quarterly, talk to them a little more often than that, and we're maybe not the best judge of it. Mm-hmm. And in that area where there's maybe a gray period and the family hasn't come forward, or we haven't reached out to who we think the power of attorney next person would be, there's very little risk actually under Altair's advisement to the portfolio, because our clients aren't calling and typically making investment decisions, investing in oil futures or doing things like that, that they're accepting our advice often after explanation. So if they started acting strangely and maybe not taking our advice when they normally did, or wanting to make very drastic changes to their portfolio, that would be a pretty clear red flag. But in the interim, if they just sort of leave it alone, the portfolio alone, there's not a constant inflow of information from the client necessary for us to manage it. So there's very little risk there, I think, that there's going to be bad financial decisions. Maybe there will be none for a period, but not bad ones.
I think one of the situations I've seen, it goes back to what we talked about with situations of mistrust and suspicion. I can think of 3 particular situations with advisors where one of the things that started happening was not so much around the investing, but somebody would call up and say, I read my current statement, and I don't see that, what is this line item on blah, blah, blah. I'm beginning to think that maybe you are moving some money on, and, there is money moving out of this account that's disappearing. And they start accusing advisors. And what the person, I can think of one client in particular, what the client didn't realize was the line item moved money out of the account, and it showed up in this account that it was a normal transaction for tax.
Yeah, I was going to say, like, that suspicion around things that usually are kind of administrative in nature, and I think we definitely see that, like a client calling repeatedly for a 1099 on an account they closed 4 years ago.
Exactly.
That sort of administrative that it comes out more in that for us versus calling and wanting to make some crazy
it's not so much
decision.
around investing decisions. It's the idea of people begin to question your procedure, that people begin, I actually had one multifamily office I worked with where the people who picked up the first were the admins, that the people, because they were getting the phone calls saying,
Right.
You just made a transfer and I didn't tell you to do that. You're stealing money from me. And the administrative person went to the relationship manager and said, I'm getting phone calls from Mr. So-and-so, and he's telling me that I'm stealing from him. And that was one of the first things that I highlighted. So the idea of money being moved and people forget why it was, and then they are mistrustful, transactions going on and being accused, forgetting about it's a discretionary account. So there's a variety of kind of straws in the wind that start to occur that if an advisor team works together, they sit down and they say, I'm a little worried about Mr. Jones here.
And often that's, if you have a living trust, and Mr. Jones is at that time the sole trustee of his own trust for his own benefit, that's when you call Mr. Jones in and the successor trustee, and you say to Mr. Jones, would it be a good time, not for you to resign as trustee, but to add your daughter as a co-trustee, okay? Because she's the successor. But we're not saying you should resign. We're just saying maybe it would be better if you had someone to help you, because these documents are confusing. It can get alarming when you see money moving around. And I think it would be better if you and your daughter were both empowered to help manage your funds, and that way you know, you could at least call on her and say, gee, why are they doing that? It might give you a little peace of mind. Of course, what you're really saying is probably you should resign as trustee, but you can take it step by step. So a living trust is a good way to start kind of moving authority down to the next generation. Now, you say you're not so worried about theft. Of course, lawyers only see the worst part of life, and it does happen. Unfortunately, the people you trust are the ones who can steal from you. If you didn't trust them, they wouldn't be able to steal from you. It always works that way. So you can't imagine anyone in your life ever taking advantage of you, or you wouldn't have them in your life very long, right? It's just common sense. But that's who gets taken advantage of. And what happens on some very old clients who have money is that adult children do a little what we call anticipatory inheritance. They begin to go after that money while the parent's still alive. Maybe you heard of Mrs. Astor in New York, who had her son selling her Marc Chagall painting, which she took a huge fee for selling the painting. I'm not sure she ever knew the painting was sold. Who raided her, who became her guardian and raided her accounts. It was her grandson that had to intervene. Here's the deal about life, and then I'll answer your question, right? You got to plan for the worst. You got to plan for the worst and hope for the best. But you really do need to pay. When you have assets, you have some money, you are vulnerable because you are a target. You are a target with money. That's just that simple. And you don't know who's going to be aiming at that target. It may be a stranger on the street. It may be someone who bumps into you on the street and said, and somehow you end up in the bank withdrawing money and giving them to that person. These are all sorts of low-level frauds. These aren't too bad. But it could be a niece or a nephew. It could be the old trick. You know the trick they do now, or the scam where they say, if someone calls their grandfather, a grandchild says, I'm trapped in Turkey, I've had all my money taken, blah, blah, blah. I need a check for $5,000 right away or I'll never get out of town. And it works and you have to do it in 3 hours. And the grandparents will start sending those checks. You say, I won't do that. Well, maybe you would, maybe you wouldn't. Maybe I would, maybe I don't have grandchildren, so I'm safe so far. But imagine your capacity is slipped down a little bit. And you don't know what's going on in the world as much as you used to, but all you know is a loved grandchild. And you think it's of course it's not your grandchild, it's somebody, some crook, right? But they've got the information somehow, and you're shipping checks overseas. Or you have the people, we see it over and over with people sending money, getting pulled in a little bit on a fraud, and they keep sending more and more money. And that's why you need financial advisors who have some sense of what you're doing and know who to call. Right? You just need a name.
Yeah, I think it's interesting because often sort of the double layer system that Altair clients live under, which is dealing with us and then we deal with their custodian who actually has legal custody of the assets, is administratively annoying. It can take longer to get wires processed and checks and things like that. But we're in the middle and we really know our clients. So even if there's a power of attorney or a successor trustee and an adult daughter who wants to get access to all that money, she can't. The custodian actually isn't only going to deal with me. So she has to deal with the advisor team who knows the client and her family well to get access to those funds. She can't just go to the custodian. So it's actually an extra layer of safety in many ways against fraud, against all sorts of things, but also this.
You're the buffer between the daughter and Vanguard, let's put it that way. And what you want in this life as you get older are buffers, say tripwires, so that either you or somebody else can't get to your money as easy. Okay, and it's just that simple. Now, with that happy note, why don't we have lunch? And we'll take, I had one question, so we won't take lunch. Yeah. Please.
In the last 6 months, I've seen 3 separate examples where the documents were all right. And one, there was a caregiver who wrote the checks. 2, a caregiver who moved in her entire family without any permission from anybody in the family. And 3, a consigliere had been with the family for years who got a document signed that changed the nature of how the family office was run without saying anything to the sort of demented patriarch of the family. So it's just got to go beyond the document.
Yeah, it goes beyond, and it goes to this idea, and I thank you for those examples. Again, expect the worst, plan for it, then you can rest easy, because you can take steps to protect yourself and your family's wealth from others and maybe some bad apples in the family. Okay, thanks a lot. We'll have lunch, right?